Hello, my name is Ian Larkins of Radius Law and welcome to our monthly commercial bulletin brought to you in association with LexisNexis. Most commercial leases include an obligation on the tenant to return the leased property to a certain condition and to pay the landlord's costs of recovering any sums due to it. Now, this was the situation in the case of Littlestone v McLeish of 2016, where the lease included the following obligation: to pay the lessor all costs and expenses, including legal costs and fees payable to a surveyor, which may be incurred by the lessor, the recovery or attempted recovery of arrears of the rent or other sums due from the lessee. Now, the court ordered that the landlord was entitled to recover its legal costs on a standard basis. That's only where the landlord could show that the costs were reasonable and proportionate. The landlord then successfully appealed, stating that the contract did not require the cost to be proportionate. The Court of Appeal agreed and stated it would only rule against costs where the tenant could show they were unreasonable. Now, does an agreement that states a variation will not be effective unless made in writing and signed by or on behalf of each of the parties exclude a variation made by email? This was a question posed in the recent case of C&S Associates UK, the enterprise insurance company of 2015. The commercial court found that an email would suffice. Now, this decision clearly gives a liberal interpretation to the meaning of signed. If businesses wish to avoid the risk of overriding previously agreed contractual terms by an informal email, then it will make sense to make sure that variation clauses are subject to stricter controls, perhaps by only allowing variations on paper and subject to the approval of a director. When a business transacts on its standard terms, any terms that limit or exclude liability for breach will be subject to reasonableness tests under the Unfair Contract Terms Law. There has, however, always been some uncertainty on what transacting on standard terms means. In the recent case of African Export-Import Bank v Sheba Exploration and Production of 2016, the parties had entered into a facility agreement which, although it was based upon a standard form agreement, it had been negotiated by the parties. The question of whether the contract was on standard terms then arose. The court, following decisions in Hadley Designs v City of Westminster of 2003, that had ruled standard terms were terms that were intended to be imposed without negotiation, and Uanda UK v WW Gear Construction of 2011, that had determined standard terms are terms which the company uses for all or nearly all of its contracts without alteration, found that the bank's terms in this case were not standard terms as they had been regularly negotiated. This case does therefore give some clarity on the meaning of standard terms. It is also a reminder to businesses that operate a take it or leave it approach to contracting that they may be subject to reasonableness challenges. Two recent cases have underscored the importance of genuinely considering mediation to resolve a dispute. In Reed v Buckinghamshire Healthcare NHS Trust of 2015 and Bristow v Princess Alexandra Hospital NHS Trust, also of 2015, the trusts were penalised by the courts for their unwillingness to cooperate with mediation. The courts were clear that excuses that the case had already been set down for a detailed assessment or because the parties were so far apart were insufficient. The ICO Data Protection Conference 2016 was held in Manchester on the 14th of March, and most of the sessions are now available online. Topics included privacy impact assessments, privacy notices, cybersecurity, and of course the future of data protection regulation. In addition, the ICO has issued guidance on the 12 steps organisations should be taking now to prepare for the general data protection regulation. The Competition and Markets Authority has taken action against Total SEO and Marketing for writing over 800 fake online positive reviews for its clients. Total SEO and Marketing, to avoid criminal action, has provided undertakings to cease writing the reviews. We've seen other instances of action against fake reviews and expect further action in this area. It is worth noting that traders can be liable even where the review is written by a third-party marketing agency. In February, MI Home Care agreed to settle a care worker's claim for being paid less than the minimum wage. The care worker's pay had dipped below minimum wage as she was not paid for the travel time between appointments. The recent Supreme Court ruling in Mohammed v WM Morrison supermarkets is likely to raise concerns for businesses about the actions of their staff. In this case, WM Morrison's petrol forecourt employee violently attacked a customer, and WM Morrison's has been held liable for his actions. Previous cases have only held an employer liable for violence under the close connection test, when the violence was directly relevant to the employee's job, e.g. for nightclub bouncers. This case proves that courts are willing to adopt a more liberal application of the close connection test. Employers have expressed dismay about the HMRC guidance, which states that when offering childcare vouchers through salary sacrifice schemes, the vouchers should continue to be provided during periods of family leave, most commonly maternity leave, when the employee may only be receiving statutory pay, leaving no salary from which the vouchers can be deducted. The guidance has been based on the understanding that vouchers are benefits in kind, which the employer must continue during family leave, rather than remuneration, which stops and is replaced by statutory and, where applicable, contractual leave pay. The EAT has now ruled that the HMRC guidance is wrong. Where the vouchers are provided by salary sacrifice, this should be considered as a diversion of salary and therefore still within remuneration, rather than have been converted to a benefit in kind. It seems that nearly every month there is a new case to provide more clarification on whether something is caught by the Transfer of Undertakings, Protection of Employment Regulations of 2006. The recent case of Arch Initiatives v Greater Manchester West Mental Health NHS Foundation considered whether TUPE will apply when services are split along functional lines at the point of transfer. In this case, Bulletin Council contracted out certain services. In 2013, it decided to split the services into 5 lots. Lifeline Project was a successful tenderer in respect of lots 2 to 5. Arch was a successful tenderer in respect of lot 1. Arch, however, refused to take on the claimant employees. The tribunal held that there was an organised group which had as their principal purpose the services contained in lot 1. Arch appealed, claiming that TUPE could not apply when the services had been split into different parts. Arch's appeal was dismissed. The Employment Tribunal was clear that TUPE is not defeated simply because activities are split along functional lines between 2 new contractors. The case of Kelly v Covent Laboratories of 2015 has tested whether it is discriminatory to prohibit a person from speaking their native language at work. In this case, a Russian speaker claimed direct discrimination and harassment because she had been told not to speak Russian at work. The Employment Appeal Tribunal found that the instruction to not speak Russian was justified in this instance, as the employer had been targeted by militant animal rights activists who had infiltrated its workforce, and therefore there were legitimate security concerns. It is likely that without these specific factors, that a similar instruction would be discriminatory. Trunky, the ride-on children's case that was made famous by its appearance on Dragon's Den, has made registered design history. Regretfully for the design owner, Magmatic, this is because its design rights ultimately failed to stop a competitor coming into the marketplace. This has been a long-running battle which had previously been decided in Magmatic's favour. In 2013, Justice Arnold found that Magmatic's competitor product, the Kiddie case, produced by PMS, had infringed Magmatic's design because although there were several differences, the products produced the same overall impression. PMS appealed, saying that Arnold had not considered the detailed differences, including the shading and other decoration. Although the Supreme Court agreed with Arnold that the correct test was whether the overall impression of the product was the same, it determined that the surface decoration or lack of it can affect the overall impression of the design. Magmatic's design registration had depicted the product in 3-dimensional images, showing it from different perspectives and angles that had demonstrated how light was affected on its surfaces. When the Supreme Court considered Magmatic's design registration, it determined that it did show sufficient differences to the competitor product that changed the overall impression. Frustratingly for Magmatic, if it had used a simple black and white line drawing for the registration, it may have had better luck at delaying Kiddie's product from entering the market. The case of Daimler AG v Ehud Garage has considered how far a party must go to withdraw its use of another party's brand on the internet. In this case, Ehud had been a Hungarian authorised Mercedes-Benz dealer. After its franchise contract was terminated, it was no longer permitted to use the Mercedes-Benz trademarks, but adverts continued to appear on the internet, referring to it as an authorised dealer. Ehud's defence was that it had asked the online publishers to cease referring to it as an authorised dealer, but they had not complied. The Court of Justice of the European Union determined that once Ehud had asked the publishers to cease the adverts, it had discharged its duty and could no longer be responsible for their activities. This case will not be welcome news to trademark owners, and it will leave them with the additional burden of taking action against the publishers. One fix for future contracts may be to include obligations on licensees of trademarks to stop all third-party infringements. A recent report by the consumer champion, money-saving expert, has named and shamed 17 well-known online consumer brands for failing to correctly advise customers of their rights to reject under the Consumer Contract Regulations of 2013. The common error seemed to be a requirement for customers to return goods within 14 days, whereas the law requires consumers are given 14 calendar days to cancel their orders from receipt and a further 14 days from cancellation to return the goods. Failure to provide a valid cancellation notice is likely to lead to an extension of the cooling off period to 1 year. The government has issued a call for evidence on how terms and conditions can be made more user-friendly and on proposals to introduce fines for unfair terms. This follows research undertaken by Which in September 2015 that highlighted how terms and conditions are often incomprehensible to consumers, particularly in the car and travel insurance market. In some instances, the terms and conditions reviewed by Which exceeded 38,000 words. The Financial Conduct Authority conducted a study in 2015 concerning competition issues with insurance products that are sold alongside other products. This has resulted in the FCA making 4 remedies. Firstly, since September 2015, a deferred opt-in was introduced for certain guaranteed asset protection (GAP) sales. This means that GAP products cannot be introduced and sold on the same day. Prescriptive rules on the information to be provided to consumers were also implemented. Secondly, on the 1st of April 2016, the FCA banned opt-out selling across financial services subject to certain exceptions. This is a very wide ban and will apply to any add-on product in any sector and regardless of whether the primary product is regulated or not. This remedy extends the opt-out ban that already exists in the Consumer Contracts, Information Cancellation and Additional Charges Regulations of 2013, which applies only where the primary product is non-financial. Thirdly, on the 1st of April 2016, the FCA introduced an obligation to provide customers with appropriate and timely information about the add-on insurance products. This includes requirements to identify the common add-on insurance products early in the sales process, show the customers the annual price of add-ons, and improve the information to help customers understand the primary products and add-on packages. And fourthly, on the 1st of March 2016, the FCA published its response to its June 2015 discussion paper and announced that in summer 2016 it will pilot the publication of a scorecard on some insurance products. The detail is still to be worked out, but it is likely to include key performance data such as claims ratios and claims acceptance rates. Thank you for joining us for this month's commercial bulletin. Please feel free to contact me if you would like more information on any of the topics covered, and if you've not already done so, you can get access to more content with LexisPSL. Any other feedback on our bulletins is, of course, also welcome. We'll be back next month with another update. Until then, thank you and goodbye.